So the Texas federal court judge who granted a limited injunction against the ATF's new rule on frames and receivers has now also ruled against the ATF and has ruled that they cannot review and make determinations on the legality of specific products. So let's talk about this. But real quick before we jump into this video, if you agree that the ATF needs to be abolished, go ahead and hit that like button and subscribe. So like I said in the intro, a federal court judge in Texas just barred the ATF from being able to review incomplete frames and receivers and make a determination if the ATF believes that they are lawful or not. The case we're going to be talking about in this video is Vanderstock v. Garland. This is a lawsuit filed against the ATF in the Northern District of Texas, and it's against that ATF's new rule on frames and receivers. The last update I had for you guys on this case was that the federal judge in the case did grant a limited preliminary injunction in favor of the plaintiff's tactical machining, and also that there were current efforts to try and get that injunction expanded. They want to expand it to protect other customers in other businesses, because right now the preliminary injunction in place only protects the single company tactical machining. That limited injunction barred the ATF from enforcing their new rule against that specific company tactical machining. However, after the court granted that limited injunction, the ATF tried to do something really sneaky. They are now trying to get around that injunction, but their efforts failed. Now, if you're not aware what this lawsuit entails, this lawsuit is against the ATF and their new rule on frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80%er kits. Under this new rule, 80%er kits are treated to actually be firearms. This new rule went into the regulatory definition of what a firearm is considered to be, changed a bunch of references to actually define these incomplete frames and receivers kits to actually be firearms as defined in the federal law. Since 80%er kits are considered to actually be firearms, they are now subject to serialization requirements and background checks as well under that new ATF rule. So that is the general rundown of what this new rule on frames and receivers did. In this case, Vanderstock, the plaintiffs requested a preliminary injunction from the court to essentially enjoin or i.e. halt the enforcement of the ATF's new rule. On review, federal judge Reed O'Connor granted a limited preliminary injunction against the ATF. In reaching his decision, he stated, "That which may become a receiver is not itself a receiver. Congress could have included firearms parts that may readily be converted to frames or receivers, as it did with weapons that may readily be converted to fire a projectile, but it omitted that language when talking about frames and receivers." He also stated that the ATF's new definition of a frame or receiver is facially unlawful. The issue here, he stated, is whether the ATF may still regulate a component as a frame or receiver, even after the ATF determines that the component in question is not a frame or receiver at the time of evaluation. Congress has not extended ATF's authority so far, he stated. That the firearm part is designed to be, or may one day become, a frame or receiver does not change the fact that in that moment, it is not a frame or receiver of any such weapon. So as a result of that, he granted a limited preliminary injunction in favor of one of the plaintiffs' tactical machining. However, in that same order, he also allowed all the other plaintiffs to file additional arguments to him to consider expanding the scope of that injunction to cover other plaintiffs, other businesses, and the customers of these businesses, and also the plaintiff tactical machining as well. Since his injunction was limited in scope, he himself recognized that the injunction only protected the manufacturer and that the customers of tactical machining were still potentially open to felony prosecution. Currently in this case, there is a battle going on between the plaintiffs and the ATF to get the injunction expanded to protect more people, more companies, and also maybe even get a nationwide injunction. However, while that was going on, the ATF tried to do something else really sneaky. The ATF asked the judge in this case to allow them to complete their review of tactical machining's products and to still make a determination if they believe that they are so-called firearms subject to that ATF new rule, which the judge just said was unconstitutional. The ATF wanted to still be able to make a determination on the legality of the products so that they could build up a case for appeal, moot the attempts to get the injunction expanded, and also is simply just a further scare tactic of the customers and other vendors, and to essentially prevent people from wanting to do business with tactical machining. So the ATF was simply just trying to snake their way around the injunction that was issued against them. In response to that, of course, the plaintiffs opposed. They stated in their motion to the court, "A simple decision tree reveals two outcomes to defendant's belated offer to classify tactical machining's product under defendant's unlawful final rule, and neither is worth facilitating. Either defendants will destroy tactical machining by eliminating demand for its product and interfering with its vendors, or defendants will attempt to nullify the effect of this court's preliminary injunction order while providing no ascertainable relief to plaintiffs and potentially opening the door for questions of mootness for the preliminary injunctive relief or joinder of new plaintiffs. Meanwhile, Tactical Machining suffers decreased sales every day and faces the complete loss of its business. Plaintiffs therefore object the defendant's belated attempt to apply the terms of their likely unlawful final rule and any delay of the resolution of the motion to expand the preliminary injunction. So obviously the plaintiffs oppose this, saying that it's simply a way for the ATF to try to get around the preliminary injunction and to try to moot this case. In response to this, the judge has just ruled on that issue. And in fact, he found that the ATF is barred from making any classification on the legality of these products. In the order, Judge O'Connor stated, allowing ATF to apply its rule while completing the classification of tactical's primary product offering constitutes implementation of the ATF new rule, which this court has said are likely unlawful. And despite defendants' arguments to the contrary, issuing such an agency determination that but for the injunction would place tactical at risk of enforcement action qualifies as agency action taken against Tactical Machining in contravention of the current injunction. This aside, the court considered permitting the ATF to complete its classification request should the parties agree that it would afford some sort of relief and narrow the dispute. Because the parties contest the utility of the completed classification request, the court denies defendants' motion and clarifies that the current injunction precludes the ATF from concluding its classification determination with respect to Tactical Machining's products. So the ATF just took another big L. They tried to get sneaky and get around the injunction that the court had put in place, but as a result, they got hit with another order which outright clarifies that the injunction also bars them from being able to review the products and make such a determination. This will have important implications for other companies who are also trying to join the plaintiffs in this case. For example, right now, 80% of Arms is trying to be brought in as a plaintiff and to also have that injunction expanded to apply to them as well. And if they do join the case, there is a potential that the ATF will also be barred from making any determinations on the legality of the 80% Arms products as well. That is significant because, of course, 80% of Arms is one of the largest manufacturers and sellers of these items. So that's a quick rundown of what's going on in the case against the ATF's new rule on frames and receivers. The ATF just got another big loss served to them. So if we get any more information on this as this case proceeds forward, I'm sure some more things are going to happen. Right now, we're waiting to see what happens with the expansion of that injunction. If we get any more information, I will let you all know. Also, like this video, like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algorithm rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by Armed Scholars, and this nation will be maintained by Armed Scholars.